Modern Real Estate Practice, page 158. Such information would affect the buyer's ability to negotiate the lowest purchase price. If the agent represents the seller, of course, disclosure of any of this information without the seller's permission would violate the agency's fiduciary duty to the seller. Other disclosures are discussed later. In practice, selling a property as is does not negate provisions already in the contract. If sellers truly mean as is, they amend any printed provisions existing in the contract that relate to the condition of systems and appliances. The seller must still comply with state laws regarding disclosure of the condition of the property. And selling a property as is does not affect the buyer's right to request an inspection of the property. A buyer is free to accept a property in its current condition, but has the right to know what that condition is. Accounting. The agent must be able to report the status of all funds received from or on behalf of the principal. Most state laws require that a real estate professional give accurate copies of all documents to all affected parties and copies on file for a specific period. Most license laws also require monies to be deposited into an escrow account immediately or within a specified time. Commingling client monies with personal or general business funds is strictly illegal. Conversion is the illegal use of such entrusted money. Confidentiality. Confidentiality is a key element of fiduciary duties. An agent may not disclose the principal's personal information. For example, the principal's financial condition. If the principal is the seller, the agent may not reveal such things as willingness to accept less than the listing price or urgency to sell, unless the principal has authorized the disclosure, and often the authorization must be in writing. If the principal is the buyer, the agent may not disclose the buyer's willingness to pay a higher price, the buyer's tight moving schedule, or other buyer facts that might affect the principal's bargaining position. The information that must be kept confidential can change if the business relationship changes, such as when a seller's agent becomes a disclosed dual agent because the broker is now also representing the buyer. Depending upon state law, the duty of confidentiality could terminate on conclusion of the agency relationship, or it could extend for a number of years or forever. Under the NAR Code of Ethics, the duty of confidentiality does not expire. Anything a realtor learns about a client that can be considered confidential must remain confidential forever. Check your state's laws for guidance in dealing with confidentiality issues. Types of agency relationships. An agency relationship can be classified based on the extent of the agent's authority. An agent's authority to represent the principal can be broad, or it can include only certain type of activity or a specific transaction. A universal agent is a person empowered to do anything the principal could do personally. The universal agent's authority to act on behalf of the principal is virtually unlimited. A court-appointed guardian, for instance, will have the authority, page 159, granted by the court, which can include caring for both the person and the property of the guardian's ward. The individual who is the subject of the guardianship, a real estate professional, typically does not have this scope of authority in a real estate transaction. A general agent may represent the principal in a broad range of matters related to a particular business or activity. The general agent may, for example, bind the principal to any contract within the scope of the agent's authority, and an entertainer may employ more than one general agent, an agent to find work, as well as a business manager to hire and supervise staff and make other arrangements. A property manager hired by the owner of income-producing property is typically a general agent for the owner. A real estate sales associate usually is a general agent of the employing broker. A special agent or limited agent is authorized to represent the principal in one specific act or business transaction only. A real estate broker is usually a special agent. If hired by a seller, the broker is limited to finding a ready, willing, and able buyer for the seller's property. A special agent for a buyer would have the limited responsibility of finding a property that fits the buyer's criteria. As a special agent, the real estate broker may not bind the principal to any contract. Disclosure of agency. Real estate professionals are required to disclose the parties they represent. Understanding the scope of the service a party can expect from the agent allows consumers to make an informed decision about whether to seek their own representation. Mandatory agency disclosure laws now exist in every state. These laws stipulate when, how, and to whom disclosures must be made. They may, for instance, dictate that a particular type of written form be used. The laws might state what information a real estate professional must provide to gain informed consent where disclosed dual agency is permitted. The laws might require that all agency alternatives be explained, including the brokerage firm's policies regarding the firm's services. Frequently, printed brochures outlining agency alternatives are available to a firm's client and customers. Whether or not the law requires it, real estate professionals should explain to both buyers and sellers what agency alternatives exist. Good business practice is to make the disclosure of agency before any confidential information is disclosed about an individual's motivation or financial situation. See Figure 10.1. A general agent represents the principal in certain business matters generally. A special agent represents the principal only for specified transactions, such as the sale of a house.